Hello everyone, this video is based on Paper 3 Module 1 of CS Professional Program, that is Drafting, Pleadings and Appearances. The importance of this subject can be understood by its practical applicability in the professional life, whether as a CS in employment or for a CS in practice. Each and every concept that has been included in your syllabus under drafting, pleadings and appearances is definitely going to contribute to your professional knowledge, which is going to be an added advantage in your professional life because these are the concepts that are going to be used on a day-to-day basis. For example, if you're required to conduct a board meeting or a general meeting, there are various documents that are required to be prepared, be it the notice for calling the meeting, the agenda of the meeting, the resolution that are required to be passed, or the minutes of the meeting that are to be maintained. This subject is not only going to help us understand the conceptual and theoretical knowledge of these concepts, but also help us understand the actual practical applicability of preparing these drafts as well as maintaining these documents. All the knowledge that the students have acquired at the CS executive level, be it the provisions from company law with respect to meetings, resolutions, appointment of key managerial personnel, or provisions from the Transfer of Property Act with respect to sale, mortgage, lease, or provisions from the various codes, that is the Civil Procedure Code and the Criminal Procedure Code, will be applicable in this subject. Let us now understand why has the institute included this subject in the CS professional program. The objective of including this subject is to provide practical orientation and develop necessary skills among students with respect to drafting of legal documents and the skills of appearing before various judicial and quasi-judicial bodies. The mission of the institute is to develop and provide high caliber professionals facilitating good corporate governance. And as students, CS Professional Program is the last phase. On completion of the CS Professional Program, you're going to enter the profession, and the institute wants you to be prepared for it and have all the necessary skills for preparing the legal documents as well as the skills for appearing before these quasi-judicial bodies. Now let us understand that the subject covers three main aspects: drafting, pleadings and appearances. In drafting, we are going to cover all those legal aspects and legal documents which have direct relevance with the work of a company secretary. For example, drafting of memorandum of association, articles of association, various contracts, drafting of minutes and resolutions. And as a company secretary, you will be required to give various legal opinions to various people, whether it is to the board of directors in case you're in employment or to your clients in case you are in practice. So when you are giving these legal opinions, what are the points that you should keep in mind while drafting the opinions? What are the points that should be included and what you should refrain from including in your opinions? These concepts are covered under the concept of drafting. Moving to the second aspect, pleadings. In general terms, pleadings are nothing but written representations that are placed before the court, telling them what are the facts of this particular case, what is the relief that you are seeking on the basis of the facts, and in case there are any claims that are posed by the opposing party, on what grounds are you going to challenge them. In this part, we are going to cover the basic general principles of pleadings and how are we going to draft the various plaints and written statements and other documents that are to be placed before the courts of law. And thirdly, appearances. A company secretary has got various recognitions to appear as an authorized representative before various quasi-judicial bodies and tribunals like the National Company Law Tribunal, National Company Law Appellate Tribunal, the Competition Commission of India, etc. The purpose of including this aspect into the syllabus of drafting, pleading and appearances is to help the students gain the knowledge of art of advocacy or the court craft. That is, how are you going to present the case before these tribunals? What is the language that you have to use? What is the body language that you should have when you are appearing before these bodies? In addition to that, what are the dressing etiquettes? What are the basic mannerisms that you should follow while you are appearing before these tribunals is what we are going to cover in this video. We are going to focus on the important drafts from the exam point of view on the basis of previous year question papers. But before that, let us have a look at a brief overview of the entire syllabus. Let's move ahead and see the overview of the syllabus. We know that the entire subject is for 100 marks. There is no division of the subject into various parts. Therefore, it is very important for us to understand each and every concept that is being covered under the syllabus. The subject is divided into 11 chapters. Each chapter has its own significance, and therefore what I suggest is please go through each and every chapter and complete the syllabus. Don't leave any chapter unattended from the exam point of view. So the first chapter talks about the judicial and administrative framework in our country. So this lays down the basic foundation of the judicial system in the country. How is the Supreme Court established? How is the High Court established? What are the working procedures of the civil courts, of the criminal courts? What are the different kinds of trials under the criminal courts? All these aspects are covered under this chapter. Apart from this, we also understand the concept of delegated legislation, how administrative bodies have been given certain powers to draft certain legislations, to make rules and regulations with respect to certain subject matters. So this is just the basic framework of how the judicial and administrative systems function in our country. Moving ahead to the second chapter, in my opinion, this is the most important chapter in the entire syllabus because this lays down the basic foundation for what? For all the other chapters that are following, because this deals with the general principles of drafting and relevant substantive rules. So it clearly laid down what are the general principles that you have to follow while drafting the legal documents, while drafting any kind of agreement, while drafting any kind of contracts. What are the principles that you should follow? What are certain do's? What are the certain do's means what should you do while drafting the documents? What you should not do while drafting the documents. So this is the basic chapter which has a lot of significance. In case you want to be thorough with the other chapters, you have to give a lot of time to chapter number 2 and understand each and every provision that has been provided here under this chapter. So according to me, this is one of the most important chapters because on the basis of what you learn in chapter number 2, you will be putting that into practical applicability in the other preceding chapters. Moving ahead, the other chapters are relating to drafting, right? Chapter number 4 to chapter number 7 are based on commercial laws. That is, you will be learning how to draft various deeds, agreements, contracts as per the provisions of Transfer of Property Act, Partnership Act, Indian Contract Act. All these provisions are coming into picture when we are going to cover chapter 4 to chapter 7. Chapter number 3 and chapter number 8 are two chapters which are exclusively given in relation to company law. Right? Chapter number 3 exclusively deals with the provisions relating to meetings. And chapter number 8 deals with the various agreements that are entered into under the provisions of company law, whether that is pre-incorporation contracts, or how you are appointing a company secretary of the company, how you are appointing the managing director, right? What are the provisions relating to MOA, AOA? All these are the concepts that are covered under chapter 3 and chapter 8, which are exclusively in relation to company law. Moving ahead to the second aspect of the syllabus, that is pleadings. So first is drafting, which is covered till chapter 8. The second aspect of pleadings is covered under chapter 9. And coming to the 10th chapter, it is about art of writing opinions. So you as a company secretary is going to give various legal opinions on various subject matters to various people. That can be, if you're in employment, you will give your advice to the board of directors of the company. In case you're in the employment, you're going to give various legal opinions to your clients. So when you are giving any kind of opinion based on any legal provision, how should you quote it? What are the things that you should be careful about in order to avoid any unnecessary penalty or liability coming upon you? So these are the certain aspects that are covered under chapter 10, and chapter 11 deals about appearances and art of advocacy. That is nothing but what are the various quasi-judicial bodies wherein the company secretary has been authorized to represent before, right? Where it can appear on behalf of its clients, and the method in which you are supposed to appear. What are the things you should keep in mind while you're appearing before the bodies, these judicial, quasi-judicial, and the various tribunals that are established? What is the body language that you should have when you're presenting yourself before these authorities, what is the language that you have to use when you are presenting a case before these authorities, and what are the basic mannerisms and etiquettes that you should have while you are appearing before these bodies. So these are the few concepts that have been covered in your syllabus. This is the overview of the syllabus. Let's move ahead and understand some important drafts from the exam point of view. So before we move ahead and see which individually as to which draft is important, let's understand how they have classified the drafts in your syllabus. So we will be understanding the drafts from three perspectives. One is drafts which are covered under company law. Second, drafts which are covered under commercial laws like Transfer of Property Act, Partnership Act, provisions of Indian Contract Act, right? And the third one is the drafts which are under Civil Procedure Code and Criminal Procedure Code. So we will be studying the drafts under these three headings. Let's begin with the drafts under company law. But before we move ahead, like I said, the chapter number 2 is most important and significant from the point of view of drafting, because it lays down the basic principles like I have already discussed. One more important aspect that has been covered under chapter 2 is the components of the deeds, right? Because from the chapter number 4 to chapter number 7, what we are going to cover, it is mainly various different kinds of agreements, deeds and contracts that we are going to draft. So when we are going to draft these documents, what should be included? What are the components? That is nothing but what is the format of these documents that has been clearly explained and laid down under chapter 2 under the heading component of deeds. So it is very important for us to be 100% be thorough with the concept of components of deed and be able to identify and know the meaning of each and every component that forms a part of the deeds. Now, in addition to knowing what are the various components, it is also equally important for us to know whether each and every component is required to be a part of every deed. Because if you take, for example, consideration clause is nothing but what is the amount payable with respect to that particular contract. In case it is a sale document, if it is a sale deed, what is the amount that you have to pay to purchase that particular property which is being sold? That is the consideration clause. That is the monetary value that is associated with that particular deed or contract. Now, but for example, if you take gift deed into consideration, whatever is being gifted to a particular person is always done out of natural love and affection. So in the case of the gift deed, the consideration clause will not be applicable. So it is for you to understand the basic concept first, that is the concept with respect to what is the document that you are drafting, whether it is a sale deed, whether it is a gift deed, whether it is a joint venture agreement. So what is the concept? You should be thorough with that, and then you should be able to identify which of the various components are going to be applicable in that particular deed or agreement. But having said that, there are a few components which are common in all the deeds, which cannot be left with, which cannot be done away with. It is to be mandatorily included, like the description of the deed, right? The heading, the document will begin with the title, and that title will be the name of the document. That is whether it is a sale deed, whether it is a mortgage deed, whether it is a joint venture agreement. So the document's title is going to be the first component of every deed. Going ahead is the place and date of execution, the place where it has been executed and the date when we have entered into the agreement or a contract that is being drafted. Third is the parties to the deed. This is also very important. The way in which we describe the parties is important. So you have to have a look at these provisions. So if it is an individual, how are we going to describe the party? If it is a body corporate, how are we going to give the description of the party? So all these are the aspects that you have to give special attention to, because this lays the foundation for the format of any kind of drafting. Moving ahead, how you will describe the party. This is also property. This is also important. You can include it either in the as a part of the deed, or later you can include it in the schedules or annexures. Signature clause and attestation clause is also mandatory. You cannot do away with in any deed or document. Testimonium is also important, right? Other things will be based on the kind of document that you are drafting. So this chapter lays the foundation for the entire syllabus on drafting, the part that is related to drafting. So please pay a lot of attention on the concept of component of deeds. Now let's move ahead and understand what are the various drafts under company law. It has been divided into two aspects again. One is the concepts relating to meetings, and another one is the various agreements that are required to be entered under the provisions of Companies Act. Let's first have a look at the drafts in relation to meetings. So we know whenever we are going to call for a meeting, there are various documents that are required to be prepared, right? One is calling for the meeting, the notice that we have to send, the agenda that we have prepared for the meetings that is required to be sent to the board members or to the general members, that is the shareholders of the company. What are the resolutions to be passed, right? Whether it is an ordinary resolution, special resolution. If it is a special resolution, we have to attach the explanatory statement under section 102 of the Companies Act. We have to prepare the minutes of the meetings. So various documents are required to be prepared when a basic meeting is being conducted in a company. So how are we going to draft these documents is what we are going to study under this subject. When you're going to prepare the notice, it can be notice for board meeting, for annual general meeting, for extraordinary general meeting. You should be well prepared for not only drafting the notice for calling the basic meetings, but also in case you have to call a shorter notice meeting. What is the provision for that? You should be prepared. In case you want to call a postponed meeting, what is the provision for that? Therefore, it's very important for you to understand the concept first, because the format of notice is going to be the same for any meeting. It is just the language and the provisions that are going to change. Second is agenda for meetings. That is nothing but what are the various points to be discussed and what are the various resolutions that are required to be passed in the meetings. Then the drafting of the resolutions, right? They will give you a particular subject matter that we want to pass a resolution to borrow funds from the bank, right? So in that case, you should authorize the board of directors to borrow funds from the bank. So that is the resolution. So what is the format of this resolution? You should be well versed with. And the minutes of meetings. So these are the important drafts with respect to meetings. From exam point of view, the two important things are the notice and the resolutions. So these are time and again asked in the exams, in the previous question papers also. The most frequently asked questions are with respect to drafting of notice and drafting of resolutions. So please pay more attention to these two aspects. Moving ahead to the agreements under Companies Act. So there are pre-incorporation contracts, that are the contracts which are entered into by promoters before the company actually comes into existence. So how are we going to draft those contracts? Who are going to be the parties to those contracts is what we have to pay attention to. Then drafting of MOA, AOA, underwriting agreement, brokerage agreement, shareholders agreement, employment of contracts when you're appointing any key managerial person like company secretary, independent director or managing director, deed of amalgamation and slump sale. So out of these, the most important ones being the employment contract, right? Time and again they have asked you to draft employment contract, whether it is for employment of a company secretary or of an independent director. Right? So these are the few things that you should focus on with respect to drafts under company law. Moving ahead to the drafts under commercial laws, it is very important for us to understand that all the formats are going to be the same for every agreement, right? So here what is going to change? The clauses and the content of each and every agreement is going to change, but the format is going to remain the same. So from the commercial laws point of view, it is very important for us to focus on the concept and the theoretical knowledge. Unless and until you don't know what is a mortgage, how will you be able to draft the various clauses that are to be included in the mortgage deed? What is the provision of lease, right? What is a partnership deed? How many partners can be there? What are the terms and conditions of partnership as per the Partnership Act? So it is very important for us to understand the theoretical knowledge in case we want to be 100% well versed with drafting of commercial contracts. In this, the three different formats are going to be for promissory note, for power of attorney, and for will. Apart from these three documents, all other documents, the format is going to be the same. You just have to know the law. What is the law under the respective enactments? Right. So I've just listed down what are the various drafts that have been included in your syllabus. But from exam point of view, a few important documents or drafts that you have to give special attention or focus to is, one is the agreement to sell. Second one is the outsourcing agreement. Next is drafting of power of attorney and drafting of will, right? And the most important one being the deed of assignment. So this has been asked multiple times, and the purpose of assignment could be different. It can be assignment of business debt. It could be assignment of shares. It could be assignment of any intellectual property rights. The assignment, the concept could be different, but they have multiple times asked the question on deed of assignment, right? Apart from this, a few important concepts being gift deed, right? So these are the things that you should focus on. Moving ahead to the drafts under the CPC and CrPC, we have plaints, written statement, affidavit, appeal, revision petition, bail application, FIR, and petition under 125 for maintenance of a wife. So out of these drafts, the most important one being affidavit. This concept is very important in the entire syllabus, right? So you have to know the concept of affidavit, and the draft of affidavit is also comparatively different from all the other documents. Why? Because whenever we are drafting the affidavit, we should keep in mind that the person who is going to sign the affidavit is going to do it under the oath, right? So it is a very significant document, and the way it is going to be drafted is also very important. So the format of a affidavit is completely different from other legal documents. So you have to pay extra attention to the drafting of affidavits. Apart from this, from the exam point of view, the other important documents are revision petition, bail application, and FIR. So these are the few concepts that you have to pay attention to under the CPC and CrPC provisions. Moving ahead to the miscellaneous topics, that are certain concepts that are from the Constitution, that is the writ petition. So there are 5 writs that are provided for under the Indian Constitution. So what are the provisions, what are the legal provisions, and how do we draft it? So it is important, but it has not been asked multiple times, but you should know the provisions, especially if petition and opinion writing. So out of the miscellaneous provision, the most important being the writ petitions. So by this, we have covered the various drafts that have been covered under the entire syllabus, whether it is company law, whether it is commercial laws, or whether it is the CPC and the CrPC. Now, what are the certain tips that you should keep in mind while preparing for the exam? First and foremost, like I've said, is be thorough with chapter number 2. Next being that you should be thorough with the concepts, the theoretical knowledge. Unless and until you don't know what are the various types of mortgage, how will you be able to identify what clause forms a part of which mortgage, right? So it is very important for us to have the basic theoretical knowledge about the concepts. Thirdly, preparing notes for what? For the formats. don't write the clauses, but create a skeleton draft of what should be the format of an affidavit, what should be format for a will, what will be the format for a power of attorney, what will be the format for various deeds or agreements. Right? And once these formats you have, keep going through them, because you should be 100% thorough with the formats. If your format is right, then depending upon what are the facts given in the question, or depending upon what is the agreement that you are required to draft, you will be able to assess what clauses are to be included in that particular format, that what is the content to be included. You can add it as and when required based on the facts that are given in a particular question. If your format is thorough, you will be able to answer any kind of question that have been posted with respect to drafting of documents. So if you keep these 3 points in mind, you will be able to give your best in your exam on drafting pleadings and appearances. If you found this video to be helpful, please hit the like button. For more such videos, please subscribe to the YouTube channel. And for any assistance or queries, you can contact the WhatsApp number that has been displayed on the screen.